Please, the court, my lord, may I be allowed to call the matter case number SS026 of 2014, State versus Rodaman Krejcir and 5 others. My lord, while still waiting for the accused to come up, I just want to place on record that, and I've already spoken to my learned friend for accused number 1, that at no stage during these proceedings or these applications is there going to be a need for a Sheikh interpreter, as accused number 1 will be able to understand the proceedings. Why there is a need to discuss this, my lord, is yesterday I had to arrange for a Sheikh interpreter in the event there's going to be one needed, and the state is going at great lengths in incurring fruitless expenditures for the interpreter to be here and without her being used, and that is why I had to engage my learned friend for accused number 1 in that regard.
I don't know what you're telling me.
All I'm placing on record, my lord, is that during the course of these proceedings, there's not going to be a need for a Sheikh interpreter for accused number 1, as he understands the proceedings.
So they don't need to check it.
Yes, I
May I ask my attorney approaches accused number 1 while we're waiting for the others? Thank you, my lord. My lord, may I ask that my attorney...
You may. Sorry?
Thank you.
Yes. Accused may be seated. Right, Ms. Vandenheefer, you said there may be an additional application which you wish to deal with.
Lord, despite our best efforts, we've gotten nowhere, and I do not believe it's in the interest of justice to push something through where you can't substantiate it. So at this point, there will be no special entries.
Thank you. Right, so then it's accused 1 to reply.
Thank you, my lord. Before I proceed, if I may just place it on record that my instructions are that the accused, number 1, was not attended to by a doctor in accordance with not your instructions but your request to my learned friend to arrange. I do appreciate that the court has no powers in this respect, but it could please be put on the record that he was not attended by a doctor.
I'll take steps to deal with it.
Thank you, my lord.
Okay, so
my lord,
do you have any reply?
Yes. Before I do so, though, may I also ask that his hand restraints be removed while he sits here, on the basis that it infringes his dignity to be before the court in this manner.
Yes, do you have anything you wish to say?
Just his hands.
No. Just let's hear from the state.
Lord, he's in the care of the prison authorities, and it's a security measure, as we had addressed this issue before.
Yes.
That's the court.
Yes.
And, my lord, there's just something that my learned friend placed
Can we just deal with one thing at a time?
Oh, my apologies, ma'am.
Yes. Yes, I decline to direct anything in relation to his restraints. Right. You wanted to raise something now
Indeed,
about...
my lord.
Yes.
About accused number one not having been attended to by a medical practitioner, my lord. I've just been instructed this morning that
Yes.
accused number one had been to a doctor,
Okay.
and they are waiting for the results, which will come at 12 o'clock. Apparently, they took some samples of him
Right.
at the court.
Okay. So, do you want to do the reply?
That's for please, sir. My Lord, my learned friend for the prosecution yesterday began by responding to say that there's absolutely nothing wrong with doc identification. He went so far as to say that the case authority, in fact, on this point substantiates that there is no problem. On the contrary, my Lord, the leading case on the matter as of 6 o'clock this morning is the case of S versus Tandwa, which is a Supreme Court of Appeal decision which I'd like to read into the record. Doc identification, as our previous allusions in this judgment indicate, may be relevant evidence, but generally, unless it is shown to be sourced in an independent preceding identification, it carries little weight taken on its own. In ordinary circumstances, a witness should be interrogated to ensure that the identification is not in error. Questions including what features, marks, indications they identify the person whom they claim to recognize. A bald statement that the accused is the person who committed the crime is not enough. Such a statement, unexplored, untested, and uninvestigated, leaves the door wide open for the possibility of a mistake. Where the state relies solely on a doc identification, however, these questions carry little weight.
Yes, well, it's the old story. On its own and solely carry a lot of weight, and the submission of the state is that it wasn't sold, and that's why in this case...
I'd like to address the court on that issue. The state submission is that there wasn't only one doc identification, there were several.
Sorry?
The state submission, as I understand it, is that there wasn't only one.
The submission is that he was known to the witnesses, he took part in an event which took place over several days, and that the identification is reliable for other reasons than the mere fact that it occurred in the dock.
My submission, my Lord, is that my reading of your judgment is that the dock identifications were the only identifications. In the circumstances, we're instructed by Tandwa to regard them as of no weight. Indeed, we're instructed by Tandwa to regard them possibly only, if at all, of little weight. If they are to be combined, you have the effect, if they carry no weight, of no product at all. Ultimately, if they carry little weight, again, the product reduces them to a state...
I understand your submission.
Right.
You take issue with the submission that because he was known, you say it's only a doc identification, little value done it.
Yes, and it doesn't assist the state to point out that there were several doc identifications.
I hear you, and the question is whether the judgment is correct or wrong on this point.
In addition,
we're not arguing before a judgment, we're arguing after a judgment.
Yes, correct. In addition, I want to argue and point out that the suggestion that that the evidence can be combined together is in order to paint some sort of picture is a method of the evaluation of evidence which arises and has been referred to by the court, the SCA in S versus Hadebe in 1998, where the analogy of a mosaic is used. And the idea being that evidence should be submitted or admitted on the basis that it might in and of itself not give a proper picture, but a court should wait and see upon the presentation of all of the pieces of the mosaic whether that presents a picture. My submission is that in this case, the various pieces of evidence that amount to identification of accused number one present only such faint pieces of a mosaic that ultimately, when you look at the picture, even with all of the pieces,
you can't say beyond reasonable doubt.
With all of the pieces there, you can't even see a picture at all.
That's the point.
My Lord, in respect of the reliance on the probabilities, my learned friend pointed out that, of course, when we are talking about beyond a reasonable doubt, we are talking about probabilities. The point to be observed, I respectfully submit, is that the standard of proof beyond a reasonable doubt is an extreme probability. And that to find against an accused on the basis of what is probable, or what accords with the probabilities, leaves open a gaping wide.
Well, do you suggest that I should say pigs fall from the sky? I ignore the probability that they don't fall from the sky and I carry on. Or do you say I should say pigs don't fall from the sky, therefore probably if someone says a pig fell from the sky, it's not correct? And that I should look at the evidence in many facets of it, looking at the likelihood of the events taking place. And then once the puzzle pieces are identified, see whether they beyond reasonable doubt establish a picture. Because that's, as I understand my duty, what I have to do.
Yes. My
So
Lord,
I take a
yes.
piece, I look at it, I say, probably this is wrong, or probably this is right.
Yes, my Lord.
If it's right, then I say there's a piece. Then I get 1,000 pieces, I look at the 1,000 pieces and I say, does that make out beyond reasonable doubt the answer?
Yes, my Lord.
That's
If
what
I'm-
I should do.
If I'm to
Now, where in my judgment didn't I do that?
If I'm to pursue your analogy of whether pigs fall from the sky, if this is to be proved beyond a reasonable doubt, I expect that one would need to be convinced not only that it was probable that somebody, for instance, witnessed a pig falling from the sky, you would need several witnesses. At the end of the day, my Lord, you would need to be convinced, and you would need to record respectfully in your judgment that you are convinced beyond reasonable doubt that pigs do indeed fall from the sky. And on the contrary, my Lord, at paragraph 126 of your judgment, you conclude, this is your final paragraph in your judgment, my Lord, you conclude that you are satisfied that the certainty on which you find in this case is a balance of probabilities which I submit is inadequate in a criminal trial. If I may,
Is that the test?
beyond reasonable
Is that
doubt.
the test? No, is that the test that you have to apply to this application of yours? Whether I'm wrong.
The test is whether another court may well
Right. So
be
let's stick
persuaded
with the
that you
test.
are, yes. As you please, my Lord. In respect of the reasonable or fair trial rights, my learned friend for the prosecution did not, I respectfully submit, respond to any of the complaints I raised yesterday. Instead, the one response that he gave was that the accused received a fair trial by virtue of the fact that evidence which was in question within the trial, within a trial, was excluded. That does not address the concern that we have raised that the accused did not enjoy a fair trial by virtue of being in physical constraints at periods within his trial or sentencing, that he did not...
Within his trial.
In his sentencing. Corrected. I stand
So-
corrected, my Lord. That he did not enjoy the right to adequate time and facilities to prepare his defence.
You say that shows him to be dangerous. I ask you whether that's the inference that should be drawn.
My
Why does
submission
it
is
mean
that
he's dangerous?
it's a
Why does it mean he's dangerous?
the
That was your-
concern on that point is that it introduces the suggestion, possibly even at an unconscious level, of a person being dangerous, which is a relevant consideration in
Why doesn't
sentencing.
it equally likely introduce the suggestion that he may escape?
Correct, which is also a relevant
But it's
concern
not
in
a
sentencing.
dangerous. Why would it affect me punishing him?
It's my submission, my Lord, is that it's a relevant consideration in sentencing whether a person is dangerous, and our
But I'm
submission,
saying to you, it's not the under influence.
I'm suggesting that at a subconscious level, that is indeed what it could suggest.
Is that good enough?
I believe it is, my Lord. The authorities seem to indicate this.
Yeah.
And in addition, the right to adduce evidence where neither the state nor my Lord respectfully gave assistance or support to the accused when he requested to be allowed to call particular witnesses and adduce a particular report. These concerns that we raised remain undisturbed, my Lord. On the substantive law, following from the above, and on a careful analysis in respect of the first of the convictions dealing in drugs, the concern that we raised yesterday that dealing in an unknown substance is not a criminal offence in South Africa, and therefore an attempt to do so would be is not punishable in South Africa on the basis that it would amount to an attempt at the legally impossible. And in addition, even if the accused... apologies.
Did not find that it was known?
You found that the accused did not know what
No, I
what
found
the
that it was
substance.
a known substance,
Yes, my lord.
but that it was not proven as against him.
Correct, that he knew. I'm operating on that basis, my lord.
But the fact that he, in concert with someone who produced and who was dealing in a known substance, assuming that it was proved.
Yes. My submission is that it wasn't proved against him that he knew what the substance was. To convict him of an attempt in the circumstances would be to convict him of a legally impossible crime.
Okay.
In respect of kidnapping, my lord, there was no suggestion yesterday from my learned friend, nor indeed is there anything with respect in the judgment indicating how, on what conduct the accused number one achieved the deprivation of the liberty of Lukele. There is also no reference to any form of attribution by common purpose or by agency. And in the absence of this, there can be no finding of conduct, and there ought not to have been a conviction on kidnapping. And equally, in respect of the requirement of intention, there is no indication in the judgment, nor was there any response from my learned friend that indeed there was intention in the form of at least foresight of the possibility that by his conduct he was depriving the victim of his liberty. Finally, on attempted murder, my lord.
When he stood in front of him and poured boiling water over him and he was restrained, do you think that didn't amount to at least a kidnapping?
My lord, with respect, even if, and that is in dispute whether it was indeed him, even if he did that, it would not amount in any way to a deprivation of his liberty. It would amount to an assault, or it would amount to the conduct requirement of an assault.
And the fact that you were with him in a place where he didn't want to be, one must ignore that.
If indeed it was the case that the conduct of others was to be attributed to him...
Well, he was there. We're not attributing. He's there. Someone comes there at his behest according to the evidence.
My submission, my lord, is that indeed what is being relied on there is attribution, and that would trigger the requirements for common purpose, which were not considered in the judgment.
Yeah, okay.
My learned friend turned yesterday to answer the question of what conduct the accused committed in order to be convicted of attempted murder. He went on to point out that, or to identify the alleged suggestion of the accused, that he suggested at some point that Lukele should be killed. There are several problems with this. It appears on the face of it to be a conflation of the conduct requirement with the fault requirement. If it is to be regarded as the conduct requirement in the form of some form of incitement or agency, it's not
subsequent to the event.
Sorry, it's a subsequent event and therefore not contemporaneous with anything that did indeed happen, and so therefore this cannot be a basis.
Seems to me to be obvious.
The continuing problem seemed to be that if
it
indeed...
seems to me to be obvious that the fact that he subsequently said, kill him, doesn't mean that at that time necessarily that was the intention.
There's a disjunction between any supposed conduct on part of the
I understand
accused.
the submission.
Thank you. My lord, and then in closing, if I may just also indicate that there doesn't appear to be any indication in the judgment, and nor did my learned friend point to any intention to kill. It must be recognized, I would submit, that it was reasonably possibly true that the accused did not intend by his conduct or anything attributable to him to cause the death of the victim.
Yeah.
There are, in addition, sorry, my lord, certain issues that were just not contested whatsoever by my learned colleague, and they relate.
He's your learned friend.
My learned friend. Apologies, my learned friend. And that is that the evidence was not subjected to an evaluation according to Stellenbosch Farmers Winery, which is required in the event of conflicting factual evidence. That the evidence must be evaluated according to the product rule.
If he didn't deal with it, do you have to reply on it? Do you have a right of reply on things he never dealt with? Do you have a right of reply as a matter of law on things he didn't deal with?
No, my lord.
So then
My
don't
lord, it
reply
would
on
be.
that. Thank
Right.
you.
My final submission is then that everything remains undisturbed.
Thank you.
Thank you.
Lord, there's the issue. I'm going to be very brief. My learned friend yesterday addressed your lordship in respect of 3 medical practitioners that allegedly examined the complainant. That's just not correct. It was 2 medical practitioners, and your lordship would recall, issue was taken with the second person that examined the complainant as that on the basis that this person was not qualified and not a medical practitioner. Bishop, my
I
lord,
think he meant 3 people.
there were 3 people. But my learned
And the
friend
third person that he went to was because you were dissatisfied with the second person. And so he said, well, the person that the witness was sent to the third person, and everyone was happy with what the third person
My
said.
lord, I still take issue with that. I have already indicated that the
You've been there.
record reflects something different. My lord, then, with regard to the attempted murder, I again submit that my learned friends, the inference that my learned friend asked your lordship to draw from that by merely being present, I said you cannot accuse them, but you could not have been convicted of attempted murder. How was he to know that somebody would come with a kettle of boiling water and pour it, and then foresee that somebody's going to die when this conduct comes out of the blue? My lord, I've got no further submissions then at this
Okay.
point.
Mr. Spannenberg.
Thank you, my lord. My lord, in dealing with the issue of corroboration, particularly as far as Lukele is concerned,
Yeah.
I want to make the strenuous submission. I've made it before, and I want to make it, repeat it strenuously as I can, my lord. There is no evidence corroborating the identification, doc identification, of accused 4 by anyone.
Yeah.
This is contrary to your lordship's finding. Your lordship found that both Peter and Paul corroborated Lukele's identification of accused 4, as I understand your judgment. I wish, my lord, to refer
You say it's a single witness and it's a doc ID
Yes.
on number 4.
Yes. If I may refer your lordship shortly to a number of passages, the pages of those passages where this clearly indicates that it was a single witness.
Yeah. I think you've argued this repeatedly.
Yes, but your lordship still found against it.
It doesn't mean I agree with you.
Well, I want to refer you to the pages where it's quite clear there.
Right,
Mr. Lord.
okay.
That's my submission.
No, it doesn't mean that I agree with you that the product or the result of the endeavour is the same. Yes.
Yes.
Page?
My lord, first of all, looks at Peter's evidence concerning as how he implicates accused number 4. It's common cause on page 173 that accused was not at Money Point during the boiling water incident. That is common cause. What is important is on page 191 of his evidence, referring to them going to Ermelo. He says quite clearly, my lord, quite
Peter.
clearly,
This is Peter.
Peter, accused 4 was not there. And again he says, I
Okay.
did not see him.
Yeah.
So he excludes accused number 4 from
Well,
it.
excuse him as someone he saw. He doesn't identify him as a participant.
Well, his evidence is so strong.
Let's just we're dealing with
Yes.
whether he's ID. So you say he doesn't ID him there, right?
Correct. My submission is his evidence is so clear that he, in fact, excludes him as not being there. Not only that he didn't see him.
Well, that's what he says.
Yes.
That's what you've just read me.
Yes. Well, in case of misunderstanding, your lordship understands me that he might have been there, but he did not see him. His evidence is quite clear that he was not there, according to him.
Okay. So he didn't see 4.
And he implicates him no further.
And that's the end of it, is it?
As far as Paul is concerned, he says that on page 803, he states that they only saw the occupants of the Mercedes Vito vehicle when they alighted from the vehicle at doctor's father's house.
Yeah.
So it's clear from his evidence he did not see them departing from Money Point. He did not see them on the way to Ermelo. He only saw them for the first time at Ermelo. Then his evidence in chief, he said he saw accused 3, 5, and 6 when they alighted at Ermelo. That was the evidence in chief. During cross-examination, particular page 4833, my lord. He adapted his version, changed it. He says, they were visible as human beings. I was not able to identify them.
Yeah, they were shadows.
It was dark, and they were 50 meters away.
So then he's assuming.
Yes. So that
Anyway, it doesn't go to 4, put it that way.
Beg your pardon, Lord?
You say it doesn't go to 4.
It doesn't go to
4.
4. Then he says, now that portion, as far as identification is concerned, should be discarded. Discarded as pro non dicta, as on identification. He then goes further and he says, I then saw them approaching the Vito. He doesn't say where they were. I've dealt with this. And particularly, he doesn't mention accused number 4. In the light of Peter's evidence that accused 4 wasn't there, my submission to your lordship is compelled, with respect, to accept that he does not identify accused 4 to have been at the Vito.
He, Paul.
Being Paul, yes. Those portions of the evidence is quite clear, my lord. It leaves no room for incrimination of accused 4 as being an Ermelo. That leaves us with a single piece of evidence against accused number 4, and that's the doc ID. Nothing else. There's no corroboration for the doc ID. My learned friend has quoted you a recent case. The old case law is also still applicable. And particularly now, and I'm arguing on the point of the reports by the police sentencing report and the
Oh, yes, we must come to that. Can you just show me that report, the one you rely on?
the portions, my lord.
We are which piece it is? SP which?
My lord, I don't have it at hand at the moment.
Okay, well, let's assume that the 4 points that you raise are in the SP series. I just wanted to ask you this question before we get off this. Do you mind if I interrupt you a little bit?
No, lord.
Okay, so as I understand your submission, these SP series contain at least the 4 elements which are set out in your paragraph 8, including that number 6 produced an ID card and 3 other things.
Yes, lord.
And those statements were portion of 1.5 odd page or 2 page history, if I can call it that,
Yes.
taken by the person who wrote the report. And the reports came in pursuant to an agreement that they were factually correct,
Yes.
and that the opinions were correct, and that the proper opinion was the opinion which was given. In other words, if there were conflicting possibilities of opinion, the correct opinion was chosen.
Yes.
And everyone, and you and the state agreed that what was in the report was factually correct, and the state agreed it's factually correct, and that's why it came in. Pursuant, I think, to questions probably from me. You agree that?
We agree. There was a mutual admission under Section 220 by the court.
Well, both of you agreed that. Now the state says, well, there was no intention, according to Mr. Mashiani, that he would agree historic facts, that the current set of facts, which conflicted with historic facts given in evidence, were the correct facts. That's what he submitted to me yesterday. Now, what do you say about that?
Well, my submission is that it's not sufficient for my little friend, for the state, to simply say, this is not admission by me because I did not understand the full implication. The most important issue...
No, it's not the
or
full implication. He says, I never intended to admit historic facts which were dealt with in the trial before me. Not before him, before me.
Yes.
And hence I would never have agree. I did not intend to agree those facts.
But it goes further than that, Lord. That's not the question.
Yes.
My submission is that my learned friend has a duty as a prosecutor not to say to your lordship, I did not agree for those admissions to be made in those reports. He should say to your lordship, those reports are incorrect. It's not sufficient to say, I would not have agreed to these particular admissions.
No, I'm just trying to deal with this agreement issue.
Yes. But my submission is
I'm trying to get to grips with what the agreement was.
Yes.
So does that mean, if he says that, would that then apply to you, that to the extent that you've admitted sets of facts which are not part of your case, that those facts are also admitted? In other words, what's good for him is good for you.
No, my lord. You understand? No. You understand?
So if you agree, if your case was it's black, and now in that report it says it was white,
No.
does your admission mean that it's white? I must ignore black.
No, my lord. With respect, you must understand the
context of the admission.
The ambience of the admission.
Well, that's what I'm trying to get to. That's what I'm putting to you.
The admission is simply this.
If he's bound by everything, you're also bound by everything.
No. The admission is this, my lord. That Lukele told these two probation officers that it was accused 6 who was there.
Okay, let's assume that.
Yes. It's not admission that he was there. The admission is that he said to them, told them he was there. It's not, if I understand you correctly. My admission doesn't entail that I admit that accused 6 was there. My admission entails that what was told by Lukele by these two probation officers that he was there. Not the correctness of what he said, but what he said.
Yes.
That's the ambient of my admission. If I understand it
correctly. And
correctly.
does that then bind you also what they said in relation to other things?
My lord, indeed, it went in. And the victim impact report is before your lordship. It's prejudicial to all the accused.
Is it not? Yes, so you say it's only the report, the fact of the report that's common cause.
Yes.
And you suggest that, yes, I understand the submission. But if the fact of the report said X and it also said Y, but Y is not good for your case, you're bound by Y. Am I not?
Well, it's a Y statement, Lord. Depends what Y says.
Well, I don't know. There's a 1.5 page statement of fact which materially, according to you in your submission yesterday, corresponds with the evidence. So are you bound by that?
I can only deal with that. To what extent I will be bound? It depends. The same as with the admissions.
Well, he's bound, so now I'm asking you, are you also bound?
He is bound.
So now you can't come and argue that those things were different.
No, what I'm saying is we are all bound, but there's evidence before your lordship that an ex post facto statement was made by Lukele, which differs from his evidence in chief. I'm not saying what he said is true. I'm saying he made a different statement to his evidence.
What about the other statements that corroborate his evidence? What must I do with that? You accept now, does that become some kind of admission on your part?
Of what happened there? No. Again, my lord, what I'm saying to you, my lord, what the admission is, what he stated there must be accepted, not as a truth of the fact. It must be accepted as what he said to these probation officers. I'm not saying to you what he's saying is the truth. All I'm saying to you is he did say that to them. I'm admitting to that. I'm not saying what he said is truth, and it's a factual truth of what occurred on that day. I'm just saying he made a statement. This statement materially differs from his evidence. Well, Lord, that's as far as accused number 3 is concerned. 4. There is no evidence except Lukele. Nothing. And we look at the judgment again, recent judgment. That is my little friend for informing the court about that judgment. Once again,
It just goes to the SCA website. I'm lucky they send me these reports straight from the library.
yes.
I don't have to go to the website, so I know this judgment.
Well, let's hope, Lord, that the accused benefits
So
from
when
this
he
luck.
says it's last night, I'm saying it's last week.
All I'm saying is I hope that the accused can benefit from this.
We understand.
We're now dealing with one extra portion of evidence, important piece of evidence.
What's that
These
now?
admissions, as far as Lukele's evidence is concerned. These admissions he made concerning the admissions between the state and myself concerning what he said to the probation officers. This is a serious impact on his credibility. Something you was not before you, obviously, when you gave judgment. I submit that this impacts seriously on his identification of accused number 4, and even his evidence as a whole. But for the purposes of this argument, I refer to accused number 4. My Lord, if one looks at the judgments and the recent judgment, his evidence, his doc identification of accused number 4 simply cannot stand. It is the chances that another court will interfere with all this evidence before it concerning his identification of accused 4 is exceedingly good. I say this with respect. Exceedingly good. If this last portion of the evidence doesn't destroy his evidence, in event it's not, it cannot sustain his evidence, at least. My Lord, as far as my learned friends on the other...
Well, the admission isn't that he said it. The admission is that they recorded that he said it.
Yes.
So it might be recorded wrongly.
No,
What if he said,
no, my Lord.
I'm referring to George, Peter, and Mary,
That's
and
not
they write there number 6, thinking that George, Peter, and Mary are number 6?
that's not the admission.
Well, it is, isn't it?
No, my Lord. The
But how
admission,
can he say more
the
than
admission
that?
is that it was recorded correctly. That's the context the admission was made. It was recorded correctly.
Yeah. Okay. Well, I hear you.
My Lord, my learned friend said, as far as the other accused is concerned, there was other evidence which incriminates them, and it particularly refers to evidence that there was a talk of a conspiracy to go and take doctor's brother at the Sassel filling station. This was said by accused number 1. Now, we dealt with this, my Lord, over the months. Your Lordship has taken my learned friend to task. That evidence is not admitted against any other accused. It's not evidence against accused 3 as he submitted particularly. It's not evidence against them.
Yeah, it's only evidence against the person
Yes.
who said it. Yeah,
So
no.
all he has-
Extracurrial statements
Yes.
belong to the person who uttered them.
So there's
Only.
only allegation the accused number 3 was there in a car with 2 other people, some 2 hours before Lukele was kidnapped. And we deal again with the blonde situation. Lord, and the fact that the identification of accused number 6 by the other witnesses is in the same boat. I don't want to distinguish, but he was ID'd by Peter and Paul on for short periods of time. He was in their presence. Their identification of him suffers the same consequences, their doc identification, as far as reliability is concerned. Lord, the issue was raised about the alibi of the accused, the fact that they were at the accused number 2, 3, and 4 at the airport.
I don't know. Yes.
Your Lordship said that at one stage during the course of the argument said, well, people well versed in and as knowledge of the working of cell phone records.
Well, they seem to have.
Yes. But there's the other aspect as well, the ASLs, the trackers. which corroborate this offer.
Well, they only corroborate the fact that the car and the phone were at a particular place.
Yes.
They don't corroborate that the accused was at that place
Your Lordship
necessarily.
Your Lordship will remember that I invited Captain Ramohale in cross-examination to go and check these alibis. Particularly the cars. He could have established the whereabouts of those cars.
Well, let's assume that the car was there and the phone was there. Why does it mean the accused was there?
Because they say so.
Well, it goes back to the...
And it cannot be contradicted, my Lord. That's the point.
Well, unless they were seen elsewhere.
Well, we're back to the precarious...
That's what I'm saying. If they were seen elsewhere,
yes.
The fact that the car and the phone were in point A is meaningless.
Well, the fact
that someone went and withdrew money or may as well be creation of an alibi that didn't exist.
Yes. That's your Lordship's finding. The state didn't attack that. No evidence was presented by the state to counter their...
Well, how do they present it? That's what I also thought about. How do they...
They go to the car pound.
Yes.
They go and establish whose possession the cars were.
Well, let's say the car was given to A, and A gives the car to B. He says,
you go and investigate them.
Says, listen, go to the airport, take my phone, this is my card, go and drive around there while I drive in a different vehicle elsewhere.
That is.
It sounds highly unlikely as a thought, doesn't it?
It's speculation in that respect. The fact is.
But it's equal. All I'm saying is, if someone says, I saw him there, and you believe that person, then that's what happened.
In light of the quality of the evidence, my Lord, I submit that your Lordship could not have...
We're back to the same issue.
Could have rejected this beyond reasonable doubt. They have alibis.
We're back to the same point.
My Lord, that's my argument in reply.
Okay. Right. So what I propose to do is I propose to go and think about the submissions which have been made, and I'll give judgment tomorrow morning at 10 o'clock after I've postponed, remanded the other matter. Right, so I don't think there's any other business then for now. Is that so? Right, so then the matter will stand until tomorrow at 10 o'clock for judgment. The accused will remain in custody. The accused may be taken down, and then I will adjourn. Right, this court adjourns until 10 o'clock tomorrow.
This morning, 6 o'clock.